This week's Property Pulse on E-Radio, chatting to CEO and founder of EZI Properties again, Andre EZI. And today we've got 6 burning questions from property owners answered. This is going to be very interesting, so make sure you stay tuned. And also, if you're listening to the podcast, be sure to share it with friends and family. Maybe they can relate to some of these questions. First of all, Andre, welcome back.
Thanks, Ian. I'm glad to be back.
So today you're going to help us and answer 6 burning questions from property owners answered. And I think the first one is the steps a landlord in South Africa must follow to evict a tenant for non-payment or rent. You often see people asking these questions on legal groups, on Facebook especially, and you always get different answers. What is your answer?
Thanks, Ian. Yeah, the questions of today was questions that came from several consumers, obviously posed recently to Property 24 as well. So I just want to give Property 24 a shout out there. And it made sense to in actual fact cover these type of topics because they are so topical and seen on a daily basis. So yes, to come to the answer, eviction is never an easy process. So there are specific steps that is required in order to do this. So I'm going to quote certain legislations and things like that so that you just understand exactly where they fit into and what protection they actually provide. So, the legal steps to evict a non-paying client are governed very clearly about the Rental Housing Act, as well as the Prevention of Illegal Eviction and Unlawful Occupation of Land Act. Okay, so as well as then thirdly, the Consumer Protection Act. So the Rental Housing Act serves as the cornerstone for a landlord and tenant relationship. So obviously there it outlines the rights and obligations of parties, making sure that it's fair and that they use a balanced approach in terms of this. So in terms of the Prevention of Illegal Eviction and Unlawful Occupation of Land Act, that's a mouthful, but it stipulates the process that needs to be followed when evicting illegal occupants. And obviously it prohibits landlords from unlawfully evicting tenants. So very good legislation that's been put in place, purely from a consumer protection position. So let me give you a guide, right? So essentially, one of the valid reasons to evict people would be, and this is in most instances the real problem at times, is that you have a non-paying tenant. Okay, so the normal process would be is to, in actual fact, make sure that the lease agreement first is reviewed and that it actually contains very specific terms, regarding firstly the payment of rent and the consequence of non-payment. This is important because otherwise you can't demonstrate that the tenant is in actual fact in breach. Right. So the second is before legal action is taken, the landlord normally serves the tenant with a notice of default. So for us as managing agents, where we basically use proprietary and brilliant systems to actually manage and do this on behalf of clients, this is a very important step of the process because this notice specifies the outstanding amount and it also gives a reasonable period, which is required by the legislation that I've mentioned. And that would be the Consumer Protection Act that says they must respond within 20 business days, okay, for the tenant to pay the arrears. So obviously if they don't, then you may proceed. Okay, so in order to cancel the lease, if the tenant then fails to pay the arrears, the landlord may cancel the lease and demand that they actually vacate on a specific date. Expectations from the courts are normally, when you approach them as well, as that they would have given them at least 1 month's notice. Okay, so once you've actually gone through the process and they've now filed an application at the court, okay, so the landlord can then apply obviously for an eviction order. So if it is unopposed, it will probably take 4 to 6 months. in order to, in actual fact, get them, out.
Sure.
That's important. Yeah. So it's a long process, that literally protects. Sometimes it's a little bit faster. We also nowadays are very much in a position to, actually they've got a tribunal at the rental housing, as I mentioned earlier, in terms of the Rental Housing Act, there's a tribunal which we can take them to, and they have similar powers to like a magistrate's court. So that process then basically is a lot faster. But that is unfortunately the process to be followed. So generally, we normally say to people, look, you need to understand that this can take 4 to 6 months. We have had instances where it has taken, a landlord, sort of, let's say, a 6-month period, and it cost him 200,000 rand to evict a tenant.
Yes, you see, it's so pricey. That's the thing.
Absolutely. Yeah. Absolutely. But, there are remedial steps that you can take. Obviously, I would rather suggest get a very good rental agent. That has, in my nature, I'm going to punt what we do. I've mentioned this on one of the other podcasts. I mean, the average, collection percentage for all the rental agencies in South Africa is roughly about 82%, as reported by TPN. And ours generally stays and remains above 90. It varies between 94 and sort of 91, 92. So we are doing roughly 10% better, which is I think a good feather in our cap, if I can call it that. Anyway, let me come back to the process. So after, then you would have to attend a court hearing. So important because, after the parties have, in actual fact, they filed their various affidavits, and the legal practitioners must then argue the matter. It depends on what happens at that particular point in time. Now, if the court finds in favor of the landlord, obviously you will obtain an eviction order, which clearly states by when the tenant must be out of the property. Then sometimes they don't vacate either. So then you can request the sheriff of the court to enforce the eviction order. So they will carry it out. They will literally go and remove them. So I think, in short, it is crucial for landlords to follow all legal procedures and to avoid delays or legal complications. Rather consult an attorney that specializes in this, and that that you will be compliant with various legislation. The reason why I'm saying that is, yes, we've all heard the horror stories where people are, I'm going to take the doors off and all those wonderful things, which are definitely illegal and that you're not allowed to do.
Yep. You're also not allowed to cut the electricity or the water, because apparently some landlords do that, hey? They think they can, but they're not allowed to. No,
you're not allowed to do that. I mean, that's a basic right, in terms of our constitution. So, you can't follow and take the law into your own hands. I mean, it's better to rather follow a process. We also have like an insurance policy, where basically if you take that insurance policy then covers the cost of an unopposed eviction. So unopposed evictions probably normally is anything between 20 and 40 odd thousand rand. So that's for the fact that you're paying around 120 rand to have that type of cover, is actually a very good route to go.
It's actually so hectic how, people claim they've got squatters' rights and all the stuff that a landlord has to go through just to reclaim his property that he actually owns. I mean, it's just beyond
you're right.
me.
I mean, but that is something maybe for a different discussion on a day, because I can tell you, yesterday I had a very interesting conversation with a developer where they entered up where they have to move 400 families, literally a squatter camp, because of the fact that they've bought, they own the land. These guys have obviously squatting there for some time, but I mean that from a political intervention versus various political parties, the mayors. I mean, the endless things that they had to do to get that in place, is quite interesting, but a very cumbersome process.
Yeah, it gets very rough. But yes, we'll definitely save that for a future podcast, Andre. I think that will be very, very interesting. Up next on the list of burning questions from property owners, how to resolve property boundary disputes.
Truth be told, I mean, that is actually a very common occurrence. I have had a very similar issue. Let me start with that. Obviously, I had a neighbor that decided that his property overflows, in terms of natural flow of rainwater. Yes, the legislation says that there's got to be drainage holes into the next property so that you have a flow, and then it can flow through that property onto the next until it reaches a drain. However, my property and his property and those around us are very flat. So it doesn't mean that we necessarily have a flow of water. So he's got large pieces that are completely uncovered, no grass, nothing. He then proceeded to build cement channels to channelize the water to a specific point, then came and just hit out 4 bricks in the wall without even any consideration or talking to me. Now, that's exactly when things go pear-shaped.
Yeah.
So I'm just using it from a personal perspective, and I'm saying, yes, it happens, and there's a lot of conflict. But, boundary disputes and things like that, can be quite a few things. It can be overhanging trees, overgrown shrubs, a wall built either too high or too far over a boundary line. And these, obviously lead to conflict. So the problem is that they time-consuming and costly to resolve. So it's better to understand, and resolve these things as much as you can amicably, and obviously then reducing your cost. Otherwise, if you're going to go the legal way, and a lot of people have done that, and these can run into serious costs. So the process to follow here is to actually just firstly determining the boundaries of your property. In my instance, it also turned out when we did that, he ran into a dispute with the other neighbor next to us as well. We stay in a cul-de-sac, but the point is only then to realize that even where he broke through, that his portion of the property, the wall, was in actual fact, and I'll talk about that a little bit just now, when you start talking about encroachment, but the boundary wall was in actual fact sitting 1.2 meters into the neighbor's property, and it's been there like that for many, many years. So then obviously, to resolve these things, again, now you've got to break down a wall and rebuild. Who's responsible? So it becomes a difficult situation to determine who originally built the wall and ignored the boundary line. So firstly, always make sure that you understand what's the extent of your property. Okay. So to know exactly, that's why even with new developments, there's pegs in the ground and all those type of things where they make very sure. If you buy in a new development, also a legal requirement is to make sure that you identify the property, adequately. People neglected in the past, to have a plot plan where they basically make a cross on the specific erven, then basically it is not properly identified. Whilst I'm on this point, I mean, this type of thing could be very, very interesting. Because remember, you can also obstruct the view, which is very applicable, like with you guys in the Western Cape. So if you obstruct view, depending on what the limitations were that you, in actual fact, have been awarded in terms of what you can do on that, property, and I'll talk about local zoning laws in a moment, but that needs to be taken into account as well. So there was a very interesting court case where an agent had pointed out, where a property would basically would be the earth. They then proceeded to build a house. This house cost 7 million rand to erect. Only later on to be found that he had built across somebody else's earth. That case, in the end of the day, by court, they had to break down that whole property. So an interesting scenario. So these things got far-reaching consequences. So talking about boundaries, that's why I'm saying best way is to try and reach some other agreement. I know, yes, often people are at loggerheads, but keep a cool mind and rather see, through whatever medium is available, how you can find a mutually beneficial solution. Okay. So we were talking about trees, can it be trimmed? Can it be kept intact? Is it damaging the wall, or is it just overhanging? If the boundaries are, built, as I've mentioned earlier, and you've exceeded into their property, then if it gets rebuilt, who will the cost be shared? How are they going to rectify this? So there's not necessarily always, and I know this is the quickest thing for people to do, is to say, listen, I am going to sue you. Let's take legal steps. And I don't want to upset all the lawyers out there, but because that's their bread and butter. But it is, let's be honest, it's going to be a costly exercise. Okay, so try and avoid it. Otherwise, do go and see an attorney. Right. Yeah. So I was talking about the local zoning. So again, let me retry that. Municipalities have got various zoning laws. So if a neighbor refuses to come to the table, and no agreement can be reached, then they can check and see what does the municipal zoning laws say with regards to specifically encroachment, or are they in breach of any specific regulation. So if so, a complaint can be lodged at the municipality, or they can then institute, obviously, legal action. But it's always worthwhile to check on that as well. So a nuisance factor for not maybe a boundary dispute, but often, in the same manner, maybe that somebody's actual fact having a workshop there for industrial purposes, which is obviously, again, talking about zoning, not allowed. Right. So there are obviously some alternative dispute resolution mechanisms. So people can as well appoint a mediator or an arbitrator to help them resolve that. They can obviously then again reach, a resolution much faster than what it would take to take this to court, because the courts are full in terms of hearings. And often it takes a year before you get a date for your matter to be heard. So I would also, again, recommend, that they follow, this. You have to, I've mentioned it already in terms of legal, action. If there is no other way, and everybody exhausted any possible agreement that could have been reached, then obviously they will then, go through the process. And depending on the value of whatever the claim or the relief that is sought, it'll either go to magistrate's court or high court. So, as I've mentioned earlier, I would rather avoid, and I would strongly say to people, do not take the law into your own hands. Again, we've seen that. You can't start cutting down a neighbor's tree or just break down the wall because it's now encroached on your property. That will, in actual fact, result in a variety of different things, which can end up like criminal charges or a civil claim against you and so forth. So keep it in check. It's better to, in actual fact, get it, your concerns to your neighbor in writing, and then to seek, the agreement that we spoke about, failing which you would then basically contact a legal expert and you would then go through with a legal process. So yeah, there we go.
In Afrikaans they say sonde met die bure. I think that's a great way to sum it up. Sonde met die bure.
Indeed it is. And I can tell you, there's been some very, very interesting cases, that the courts have had to deal with. And sometimes, you're just dealing with a bully, a person that just, they don't care about other people, and it's unnecessary. I mean, most of these type of things should be easy to resolve, with full understanding that a tree can have roots and whatever that is, in actual fact, lifting a wall, causing it to crack and break and whatnot. What people don't understand is, you may now say, listen, I'm not going to do anything, but ultimately, I can successfully then, have a claim, because you would have to rebuild if I win. You would have to rebuild this whole wall on your own cost. And that often can cost 50, 100 odd thousand rand. So it's not cheap exercises.
Definitely not. Andre, as we move on to the next one, how do I remove my name from an existing home loan, and how do I navigate house ownership post-divorce? This is another quite a messy topic.
Indeed it is. So I'm going to deal with it in two sections, if I may. So essentially, it happens quite often, in fact, that even post-divorce, we end up with the fact that there was an agreement and one of the parties had to be removed, that it didn't happen for whatever the reason. Obviously, there's often a charge that will be levied in order to, it's a reduced charge, but I mean, still, to actually remove one of the people and then transfer the other half share, into somebody's name. But it does get a little bit more messy than just that. So a good scenario that was depicted here was basically where they got divorced, and the ex-husband basically is now, is overseas and unreachable. They don't even know where to find him. So, on that basis, one would in actual fact have to apply, to have your partner substituted as a debtor, which means that they would have to be removed. So if the undivided half share, as I've mentioned earlier, was sort of not formally transferred, you would need to enter into literally an offer to purchase, to buy or whatever. But let's say there's a settlement agreement. We're talking about divorces here. So if the part, is basically then sitting in that situation, notice would have to be given to a bank to cancel it and transfer it into, a single person's name. So let's assume that did not happen and the transfer didn't happen. Okay, so essentially all you need to do is then to approach, the court via your conveyancer, to transfer the that half. So there is other than that, there is no other way. If they can't, in the scenario that I've mentioned, if that person cannot be found, they would publish it in the papers, and everything. They would then apply, and they will get the courts that will appoint the sheriff as a substitute to sign on their behalf. Okay. So that's how they would go through the process of getting, that property half transfer into a name. So, as I mentioned, we often have had scenarios. Now they've divorced, all those things, for some strange reason it didn't go over. Now the spouse is not overseas; he is quite here and available, but he just refuses to sign. So that also becomes, a bit of a dilemma. So. Again, you can refer back to the settlement agreement that had been issued and signed at court, but that doesn't automatically just entitle the transfer. So again, you would have to follow that process, see a conveyancer, get them, and then they would have to, in actual fact, probably bring an application in order to force them to sign. That the transfer is going to just effect over to the other party, right? So normally, we were speaking about divorces here. So if there's a joint bond, obviously, then there are literally two options. They may decide to rather sell the property, okay, as part of the settlement agreement, or if the party that basically they've agreed that party will continue owning the property, they would have to qualify in their own rights to obtain a bond just in their name, and then they can basically, essentially, let's call it a buyout of the other spouse. So failing which, it obviously means that they cannot effect, unless they have somebody that's either going to come in as a guarantor or as a co-applicant. They would not be able to actually keep the property despite the fact, because they cannot afford and pay the home loan on their own. There are ways around it. Obviously, it's by virtue of court order that the one spouse then agrees as part of the let's call it maintenance or whatever, that they will continue to pay a portion of that bond, and whereafter as the property is then settled, it will remain with the other spouse. But again, these are normally clearly determined with when they consult the divorce attorneys. Why I mentioned this one today was really just to make sure and say to people, if you're going to get divorced, there are instances where the property is not transferred, despite the fact that there's a court order to do so, may have been paid off and all those type of things, but it did not happen. We've even had the same thing, a spouse passes away, and that half sometimes probably, and it's normally an estate that had lots of difficulty and never really got wound up or whatever the case may be. But we have seen instances where the other half was not transferred, which means that, it complicates the transfer process a little bit more, because that half now needs to be transferred over. It triggers tax events and all sorts of stuff that needs to be taken into consideration. So in the end of the day, make sure that when you speak to your conveyancer and select the correct attorney, for that process, that they know, and I'm talking about divorce attorneys or whatever it is that you are talking to make sure that they eventually transfer the property into your name. Otherwise, you will only run into issues down the line.
Okay, very good advice there, Andre. Thank you. And now we move on to another one. This is also quite a hot topic. Tenants versus landlords. Early lease termination disputes. And I mean, you can get so many different answers here because you have so many different scenarios. But what is your take on it, Andre?
Okay, well, it's actually quite clearly governed. I mean, we did talk about, landlord and tenants in one of the webinars very recently. But there are two clear pieces of legislation that really determines exactly what should happen. So that being the Consumer Protection Act, and then obviously the Rental Housing Act. So that tells you what the rights and penalties are that you could levy, and so forth. So let's talk about the right to terminate a lease earlier. So obviously Section 14 of the CPA provides them with a right to terminate any fixed term lease agreement prematurely by merely giving 20 business days written notice. And this is where people often say, yeah, but that, it depends on what the contract says. I need to remind our listeners that no contract that you have written or any lease agreement supersedes law. And that's something that people often forget. You can't write a contract and say this would be the scenario, but yet it's contradictory to what legislation says. It doesn't replace legislation. So that's just a rule of thumb to often remember. Okay?
Yeah.
So as I was saying, then obviously most contracts would obviously provide for some sort of termination. Hopefully it also covers the section about, what happens in the instance of early termination. So general speak here is that a tenant will remain liable for any amounts owed to the landlord in terms of the lease agreement up to the date of cancellation. Okay, so if you're behind all those type of things, you would have to pay that. Now, it's clear that one needs to also then look at it, because there's a very interesting thing in terms of the CPA, because a distinction must be drawn between tenants who are natural persons and those who are juristic persons. So, because remember, the CPA, Section 14, does not apply to juristic persons. So, but there's other ways that management companies such as ourselves bind the directors of a company by doing personal suretyships and those type of things. So it's not that easy to just walk away from it. But I just want to make the point that obviously the CPA does not apply to a business. Okay. Now, we were talking about what is a reasonable penalty, for a termination of a lease. It all depends on what is the remainder in time. So the CPA allows for this, but they, as I said, they specifically make provision for what is known as a reasonable penalty. Okay, so the amount cannot be fixed, and it will depend on several factors. So as I mentioned, the remaining period, the effort required to find a new tenant, the loss of income to the landlord, and any other reasonable costs that the landlord would incur due to the early termination. So those are very important factors in order for them to determine what is reasonable. Okay. There are obviously cases, and this also is often a bone of contention, may the landlord not use the tenant's security deposit to cover the reasonable penalty or any portion of the unpaid rent. But let's just talk about the reasonableness of the penalty quickly again. If it is too excessive, they obviously have the right to challenge it. So that's exactly where normally the guys end up at the rental housing tribunal or even a court, where they can apply for mediation. Okay. If they don't agree. So a rule of thumb, we've seen it is reasonable and that they allow. Let's say that if you've got a 12-month lease, you only stayed there for 4 months and you want out, they would grant 2 months. So, that's a good, reasonable rule of thumb. If they're 9 months into the lease, there's 3 months left. In general, the Rental Housing Tribunal will say, listen, we would be happy if we then basically grant you an order that says 1 month's rent is reasonable, which often then means that they are going to use your security deposit to cover that. Obviously, these protection mechanisms have been put in place to help and assist, tenants out there, because it actually forms a very large portion of home ownership, or actually having a roof over your head is in terms of being a tenant. So, a very important section to consider, as I've mentioned. But the old. I'm just thinking now about the olden days. A contract was a contract, and you bound into it. If you actually 6 months into the contract and you left, you were liable for that whole 6 months. Yeah. Which you can argue, depending on which side of the fence you sit, that it's fair and reasonable. But let's be honest. If you can find another tenant, you're not making a big financial loss. It's within another month. Then 1 month's penalty or whatever it may be, could be as maximum of 2, is quite reasonable. So it's good that they, in actual fact, have stepped in and sort of to some extent protect the rights of a tenant as well. I know, and that's again another interesting debate, because obviously there is, and you were talking about specific wording earlier. So there's a very interesting wording that comes back from Roman Dutch law called hier gaat voor koop, which means the rights of a tenant is protected above that of the landlord. So a lot of things have changed. To some extent, yes, they have to protect them, because obviously the landlords can really take advantage of it. But there are clear guidelines, as I've mentioned, in terms of the 2 pieces of legislation that really just governs this. And one should be able to resolve these matters within the guidance of those.
That was a brilliant answer. Thank you so much, Andre, because, it's so true what you say. A lot of the older landlords still go with this thing of, if I can't find a tenant, then you're going to pay for the remaining 6 months of your lease, that kind of mentality. But as you said, things have changed so much, eh?
No, very much so. And I mean, if you ever find yourself in a situation like that, you as the tenant can approach the rental housing tribunal and say, I do not agree with this. And as I said, I mean, they will then do a clarification order in terms of saying, this is how we see it, this is the situation, and issue an order. So that's normally your best recourse.
Okay, perfect. And Andre, thank you so much. That was very interesting. And now we come to one of the final ones, legal requirements for building plans and municipal clearance certificates explained. Can you help us with that one as well?
Absolutely. Now, this is a very interesting area because for too long, I think there's a lot of people who have just started taking the law into their own hands. I suppose you couldn't say it's the law in own hands. Let's say they've taken the brick and mortar into their own hands, right? And they started building onto their house without any approval. So, legislation is quite clear. You've got to obtain approval when you actually build, you enclose your property, like a wall in the front of your property. You've got to get an approval when you do an extension, when you put in a pool. Those are all good reasons that I mentioned, which will mean that you need to, in actual fact, submit an alteration of your plans to the council. So, I'm again going to just quickly touch on the pieces of legislation that came into play to protect the consumer because they felt that it was needed. So the first one is both of them are interesting acronyms because that sounds like a swear word. So the first one is the Spluma Act. Okay, which really just stands for the Spatial Planning and Land Use Management Act. That became operative in 2015. So in the Western Cape, they under-issued what is known as the LUPA Act, which is really the Western Cape Land Using Planning Act. Now, what these do is that they have clearly made it a legal requirement that a Spluma certificate or a clearance certificate must, in actual fact, be issued, by council, making sure that the property is still exactly the same as the original plans. Bylaws and regulations, zoning, and everything has been checked, and that they are happy that it's used for the intended purpose of what the land was allocated for, as well as in terms of the buildings that is erected, and that they are all clearly approved by council. Now, having said that, so it is a predicament in the country. Obviously, a lot of plans in some areas were lost, which it makes it more difficult for them to, through fire and water and all that. But I'm just thinking about two large metropolitan areas where they've had these issues. So they can't really do it. And also for practical purposes, let's use Gauteng. It's a lot more difficult, with the amount of housing that is here, in order to enforce sort of Spluma compliance. So currently, Mpumalanga and then the Western Cape, a Spluma certificate is required before any transfer can happen. So building plans must be in place. We've even started finding that some of the banks are insisting when they basically send out their valuators and they believe that there could have been some changes. One bank in particular, doesn't really matter, they ask for plans anyway. So if the plans are not exactly the same as what the property is, because of Spluma not being implemented like in Gauteng, they then refuse to actually provide the finance on the property. So this really just is a process to stop the unscrupulous homeowner from just building onto their property. My son told me about a property that they saw today, which really was amended, altered, and now really is 5 different dwellings on a single earth. Now, you can imagine that is firstly illegal. Secondly, I'm convinced that there's no plans in place.
Yeah.
And yet then you have an owner that is of opinion that he can get 5 million for his property, which is actually against general building regulations and everything that I've mentioned. So building plans, I think the message here was really is to say to people, listen, make sure that when you buy or you sell your property, make sure that you have proper approved building plans. And having an architect that have drawn them up, but they were never submitted, that just doesn't fly. It has to be approved by council. Because we've had instances where people say, here's all the extensions. It architects or everything, but it does not have the municipal stamps, which means they did not agree, to the alteration. So a very important point to remember.
Okay, Andre, thank you so much. And we're almost out of time, but I want to ask you one final question. On everybody's lips at the moment, will interest rates come down? What are the experts saying?
I think there is more consensus than what we had 2 months ago. We're definitely hoping to get at least 0.5%. I think it will be good for stimulation in the economy. Obviously, when you look at inflation, in terms of the targeted inflation, it is well within the bands that they wanted to keep it at. I'm going to actually sit on the fence a little bit, because the reason for this is the Reserve Bank governor, I think, is extremely conservative in their approach, and we may see a 25 basis point reduction. But let's be optimistic and then say we hope that it could be 0.5. I certainly am one of those that believe, the country and to stimulate our economy, we need to, in actual fact, get at least 0.5%. That 50 basis points would do wonders. Reducing obviously the indebted nation, because that is the unfortunate gospel truth. We have a nation that is hugely indebted, and obviously, after COVID, very low interest rates. It was so appealing. People flogged in and bought properties. Yeah. Although the banks factor in and they say, listen, if this thing has got to go up, by 2 or 3%, so in their selection criteria, to approve you and look at your affordability, they consider all these things. But when it grew beyond that, that's the problem that people have. They no longer can literally afford it. So, in short, we generally hope for a good relief. And I, for one, awaiting with abated breath to hear soon when we're going to know what they've decided.
Magic. Andre, thank you so much for answering those burning questions today from property owners and even tenants. Much appreciated. And of course, Andre is the CEO and founder of EZI Properties. If you're looking to buy or sell, give EZI Properties a call on 010-035-3636 or check out their website, EZI Properties. That's EZI Properties.co.za. Andre, thank you so much, and until next time.
Thank you, and I really appreciate it. And we hope that on the 13th, when they meet, National Treasury, would be in a position to at least give us some good news. Yeah,
that will be a nice way to end this year.
100%. In fact, I just checked now. Sorry, I said the 13th, but that's when they do the repo auctions. The monetary policy policy committee only meets on the 21st. So 21 November, people.
Oh, okay.
Let's
Still a
all
bit of a
hold
wait.
thumbs and pray.
Okay. Okay, but it's coming. It's coming. It's around the corner.
Absolutely.
Andre, thank you so much. Much appreciated.
Thank you.